hearing an appeal for the court against Royal Wolverhampton NHS Trust, Polmear and another against Royal Court Cornwall Hospital NHS Trust, and finally Purchase against Ahmed.
May it please my lords, my lady, continuing on from yesterday, I've been discussing with my learned friend Mr. Pitchers the division of labour and the respective issues upon which we've agreed to talk. There's an outside chance that my learned junior and I may spill into my learned friend Mr. Pitchers' allotted 2 hours, and he's kindly agreed that if that is the case, then so be it, but we undertake not to eat into any of my learned friend Mr. Maskery's time.
I'm not sure we'd let you do so anyway.
I'm grateful. I'd never dream of in any event. Picking up on the issues that emerged during my submissions yesterday, it would appear that the defendant and the respondent, and we'll await to see what they say, is not really pursuing the argument that there must be presence at the breach of duty. That is arguably a development from the position adopted in paragraph 30 of the respondent's written case, which is on page 261, which is to the following effect. Proximity exists where the claimant witnesses the breach and immediate risk of injury. This is why the term accident is used. I'm not sure where the admission or confirmation that presence at breach will not be pursued as a control mechanism fits into that, but the focus appears to be on the nature of the incident that is witnessed and how it is defined, whether it's defined as an accident or an event external to the primary victim. And it's upon those issues that my submissions this morning will focus. And it's instructive when considering that point to consider the nature of the cause of action which secondary victim claims are concerned to promote. And it is what is termed in an old-fashioned sense nervous shock, which is a label which is doubted by psychiatrists and so on. But in the legal sphere, it is broadly easy to understand what is meant by that. And the best conception of it is in Lord Ackner's speech in Alcock at page 563F. And I remind the court of what his lordship said there.
5638?
563F, my lord.
Oh, F, sorry, yes.
So these were the 5 propositions which we characterise as his lordship's attempt to distill the jurisprudence into some recognisable control mechanisms. But at 5, his lordship characterises the nature of the action which secondary victim claims are designed to promote. Shock in the context of this cause of action involves the sudden appreciation by sight or sound of a horrifying event which violently agitates the mind. That is significant for reasons I'll develop, because Mr. Justice Auld attached much significance to those words in the case of Somerset, Taylor against Somerset. However, that's the gist of this cause of action.
Well, the trouble with that is it seems to be based on a sort of 100 years old medical understanding of psychiatric injury, and one doesn't have to buy into that in order to support or justify limitations on recovery.
Well, one doesn't have to buy into that, my lord. And in another arena, we may be contending for a more broad, more enlightened test. But what we say is that on those existing control mechanisms, for good or ill, deriving as they may be from rather old-fashioned psychiatry, we succeed. And those are the tests within which we say we fall. But bearing in mind the nature of the action which is promoted by secondary victim claims, it's instructive then to consider what the role of the control mechanisms is. And the role of the control mechanisms is to limit the class of people that can claim for shock. Because as Lord Wilberforce said in McLaughlin, which is referred to later on in Lord Ackner's speech, one cannot simply compensate everyone who experiences that. And so the control mechanisms restrict the claim for shock, but they do reflect the nature of the cause of action for shock. And I reiterate what they are. Close ties of love and affection, in other words, relationship proximity, physical proximity or in time or space to the relevant event, and the last one is direct perception of the event through sight or hearing, and one cannot be told of the event. And so they reflect the nature of the cause of action for shock. And it's significant that in none of those control mechanisms do they refer to the type of damage that must be witnessed or the type of event that must be witnessed, other than it's a given that it must be horrifying. And so there's no requirement within the control mechanisms that the horrifying event which must be witnessed is in the nature of an accident or an event external to the primary victim. And I outlined to the court yesterday 6 law lords who formulated the control mechanisms, those 3 simple control mechanisms in various ways. I fear I gave the wrong reference to one of them. Hoffman in White, Lord Hoffman in White is 717G for the court's records. I won't detain the court by going through all of them, but I simply refer specifically to what each of those law lords described as the incident to which there had to be physical proximity. And I quote verbatim on each of those control mechanisms. Lord Steyne, White, page 711E for my Lord and Lady's records, said that the physical proximity had to be close to the incident in time and space. Incident, not accident. Lord Wilberforce, McLaughlin, for the record 599A, talked of proximity of such persons to the accident. So that's one reference to accident. Lord Ackner, in Alcock, 564F, shock has come about through the sight or hearing of the event. Lord Lloyd, in Page, for the records 1177C to D, proximity to the event. Lord Gough, White, 687F, closeness in time and space to the incident. Lord Steyne, White, 711E, close to the incident in time and space.
Sorry, what was that last reference?
711E, my Lord.
Thank you.
Lord Hoffman White, 717G, must be present at the accident or its immediate aftermath. So out of 6 law lords at the highest level, only 2 refer to accident and the rest refer either to event or incident.
I mean, is this really how we work out what the law is? You have to look at the context in which they make their choice of words.
Yes.
If the context was what was plainly an accident, the fact that they call it an incident may not make any difference at all.
Well, I say it's significant.
Nor were they applying their minds to the question of whether you can have the event can simply consist of an injury without any event that produces the injury being witnessed. And so we have to address that as a question as to what the law should be there, I think, or what the overall rationale is and whether it encompasses the situation of an injury without any event witnessed that causes the injury.
Yes. My lords are correct that their lordships were dealing with specific situations which confronted them, which were all of the nature of an accident in the classic sense. And the concern may be, the their lordships didn't direct their mind to the distinction that my Lord Legate articulates. However, I draw the court's attention to two further dicta from Lord Griffiths in white and Lord Stane in white, which were, if I may put it like this, a summary of legal history of the law of secondary victims. Lord Griffiths, it will be remembered, was a dissenter in white to the extent that he said that the police constables at the Hillsborough disaster could not recover as employees, but he felt they should recover as rescuers. And to that extent, he was a dissenter, as I understand it. His comment about nervous shock claims is very relevant. And I refer the court to 679E. Where his lordship says between E and F, and this is what I describe as his conception of the legal history of this claim. Here we are considering the tort of negligence and the nature of the duty of care owed to one who negligently creates a catastrophic situation, in order that there shall be some limits to the consequence of the negligence for which the defendant is to be made liable. The law imposes the controls I have discussed in the Alcock case. So his lordship is not confining it to a problem of witnessing accidents or...
I would have thought that's quite strongly against you. He's not saying there that somebody who negligently causes death or injury, which may occur in an extremely upsetting way, he's saying a catastrophic situation in which people are injured or killed.
Well, what I say, my lord, is that those words are sufficiently broad to encompass all the horrific events.
But he was using them to describe the Hillsborough disaster. I mean, how you can say that because he uses language that in another context could describe something else, that means you've got to incorporate within catastrophic situation everything you can think of that might conceivably fall within that phrase. I just don't see how you get it out of a pithy comment about a unique event.
Well, the significance to which I attach to those words is that catastrophic situation encompasses all manner of distressing happenings. Witnessing people being crushed in pens who may or may not ultimately be injured, that's imperilment. Witnessing not the injury, but that event. And I say that goes to the nub of these claims, which is shock in the mind of the secondary victim and what the secondary victim perceives, not what is happening at any particular point in time to the primary victim. I refer also to Lord Stane's comment in White, and I do acknowledge it's a general discourse, or part of a general discourse, at 711E. Forgive me, 711C. The leading decision of the House of Lords is Alcock. Before this case, the general rule was that only parents and spouses could recover for psychiatric harm suffered as a result of witnessing a traumatic event. And there's no reference or tethering there to any particular type of incident in the nature of an accident or any particular form of injury.
But I mean, as a matter of history, they were all accidents, weren't they?
They were.
So when he's using traumatic event, he's simply referring back to the legal history of nervous shock cases.
Well, he is. But as my learned friend Mr. Weir pointed out yesterday, since Alcock, the courts have operated in the clinical negligence sphere, and it's apparent that they have moved to the language of horror instead of the language of accident or event. And I refer to two specific quotes from Shorter and Runane in that regard. Swift J in Shorter 1282, if I may.
You can show us as many remarks taken out of context as you like, but I don't think you're going to make much progress that way. What you really need to apply is what is the rationale for the exception and how far does it extend? And taking remarks of judges in other cases where they haven't been addressing that question, isn't, when we're here with 7 judges to decide it on grounds of principle, not necessarily according to a dicta in previous cases, won't assist you much.
Well, it does, and it does, and to this extent, I echo my learned friend Mr. Weir. When one considers what the courts say when they're not confronted with an accident situation, and when they're confronted with an internal to the primary victim situation, which is exactly what happened in Shorter and Renane.
We know paragraph 214, is it? Middle there.
So I've got the wrong.
Paragraph. Yes, 214, my lord, yes.
In the middle of that paragraph.
Yes, indeed.
So you're saying that at page 1282, you're saying that where you haven't got an accident,
in the classic sense,
as you won't usually have
yes,
in the context of medical negligence, the courts are using analogous language of something being horrifying,
yes,
rather than the stress on some sort of event.
Indeed.
Yeah.
But look at the previous paragraph, 213. That's an analysis of whether the claimant in this case could say that they had been involved in the event.
In inverted commas.
Yeah.
Yeah. Can I ask you this?
Yes.
Okay, so we've got 2 situations. One is one in which there is an accident.
Yes.
And the other situation is where there isn't an accident. Now, let's take the accident situation first. What I'm just trying to pinpoint is what is it that must create the shock that the law has traditionally required. Even in that situation, is it the accident or the injury and death consequent on the accident? So the reason I ask is that one might have thought that the inclusion of the immediate aftermath would indicate that the shock to the system required is by seeing the injury or death and not the original accident, because clearly you're coming to the hospital, the immediate aftermath.
Yes.
You're not coming to the scene of a pile-up or some sort of accident in that case. Is that right? That it's the shock created by the seeing of the injury or death, even in a case where there's an accident?
Yes, and the nub of it is the shock within the mind of the secondary victim rather than what ultimately is the fate of the primary victim.
But I mean,
why is there any requirement of the immediate aftermath then? Why not 5 weeks later?
Well,
in the mortuary when they first see their loved one for identification.
And if I may just add to that, I mean, how is your answer compatible with what actually was the result in Alcock, where all the claimants in Alcock went to the mortuary afterwards, saw the bodies, beaten, mangled bodies of the relatives, suffered shock at that point?
well, as my learned friend Mr. Pitchers will expand upon, other jurisdictions have identified this precise problem and have recommended the liberalisation of laws in that regard.
Right, but sorry, you were giving us an account of what it is in the law that is the relevant event, and we're all asking you, how is that compatible either with authority, the aftermath doctrine, or with the facts in Alcock?
Well, the account I'm giving is compatible with the law's conception of the cause of action, because it rewards, if I could use that phrase in this context, damage, psychiatric damage for shock, the perception in the mind of the secondary victim. I make no bones about it. I don't defend the restriction of the immediate aftermath principle. I say there is a very good argument for saying it should be extended indefinitely. But that is a control mechanism to stop a proliferation of claims. It doesn't undermine the validity of the claims that are advanced within those control mechanisms. And I say that we fall comfortably within those existing control mechanisms for the purposes of the appeal.
So the immediate, I mean, let's just be clear about this. The immediate aftermath in McLaughlin O'Brien is of somebody just witnessing people who have been injured or dead, as I understand it. Is that not right?
Yes, it is. The fact that the essence of the case is shock in the mind of the observer is confirmed by Lord Oliver's conceptualization in his 5 propositions, 5 elements, as he calls them, of death, injury, or imperilment. So the word imperilment underlines the fact that what the injury or the experience, if I can put it as neutrally as that, which the law looks to, is what is going on in the mind of the secondary victim. And so it's irrelevant what actually is happening to the primary victim in the final analysis, whether they are ultimately injured or not. It's the impression that creates on the primary victim. I'm unable to defend on a logical basis the restriction of the immediate aftermath principle at, say, 2 hours after the event, other than to observe and acknowledge that it's a control mechanism and it's there.
Well, you're in the good company of Lord Hoffman, for example.
Yeah. But that doesn't mean...
But there is a distinction between, even within the narrow confines that you would submit it is,
yes,
of an immediate aftermath,
yes,
what is the shock element? Is it witnessing the event, the accident in this case, of McLaughlin O'Brien, or is it witnessing the injury?
Well,
the fact that the courts have gone on in other cases to say, oh, well, you're outside the immediate aftermath when you come to the mortuary, is not the point. The point is, if you are within what the law has controlled, in their controlled notion of immediate aftermath, is that the accident being witnessed, or is it the injury stroke death?
I believe I understand my Lord's point. It is, how can there, for example, be the immediate aftermath of imperilment? I say that in reality there can be no immediate aftermath of imperilment, and if the immediate aftermath distinction is to...
Sorry, I'm not saying that. I've not made myself clear. I apologise. What I'm trying to pinpoint, because I think it is an important question...
Yes, my Lord.
...is what is it that the shock element is doing in the law? I think it's being put against you that the shock element has to relate to an accident, because it's got to be the accident that is shocking or horrifying. The fact that one has a concept of immediate aftermath might suggest that there's a problem with that, because, as I understand it, but I may be wrong about this, the immediate aftermath is including situations where the secondary victim comes along and sees the effect, that is, the injuries and death of the primary victim, rather than having seen any element of the accident, so to speak.
Yes.
And if that's the case, that's rather important, because it would mean that you don't need an accident as the shocking trigger, provided the injury or death is the shocking trigger.
Yes, one doesn't need for there to be a witnessing of a particular type of accident for want to recover for, I term it nervous shock. It can be the immediate aftermath of an accident. It can be mere imperilment, which doesn't ultimately lead to injury.
But I mean, isn't the sense of immediate aftermath that you come upon the scene, the bodies are sprawled all over the road, yes. You can see the cars, you can see there's been an accident. Yeah. It's that which is the particularly shocking aspect which the law, if you suffer psychiatric injury as a result, is prepared to compensate you for.
It may be, but it does not necessarily have to be. So there are situations involving not only aftermath of accident, but other death, injury or imperilment per Lord Oliver, which can operate to give rise to this claim.
Immediate aftermath, as I understand it, is there as a very limited extension of the circumstances in which there is legal proximity.
Yes.
Where the person who's causing the accident by his negligence, whatever it may be, driving, might expect to shock not merely people who are there, but people within what you might call the rescue principle, who would come running the moment they heard about it. I mean, take the demolition of the school in Aberfan.
Yes.
All the mothers in the street would come running the moment they heard about it, whether or not their son had actually been killed.
Yes.
So that the proposition you can't have an aftermath in a case of imperilment, I don't think is necessarily a good one. But the real point is that these are people who are almost constructively present at the accident because they were people who would come running the moment they heard of it.
Yes.
I think that's what the case is. That's how the aftermath principle is justified. I can't now remember the precise page, but I recall seeing the rescuer principle in the forefront of the justification of the immediate aftermath.
And in Alcock, Lord Oliver said it would not have mattered in Hambrook had the claimant's children been uninjured. One will remember the facts of Hambrook. It was the runaway lorry which caused, as it were, nervous shock before mother even realised that any of her children had been injured. The fact that one of them turned out to have been injured was neither here nor there. It was the thought that one of them might have been through seeing the lorry go round the corner. And that situation gives rise to recovery. I submit does not undermine the case we're advancing, because in each of these factual situations, whether it's accident, actual injury, death, imperilment, or aftermath of accident, the common feature that links them all is the shock on the mind of the observer, the second.
Can we just, it would help me to just go to McLaughlin O'Brien.
Very good, my lord.
I mean, if we go to page 594, paragraphs A to D tell us what happened in that case. So the wife is 2 miles away. An hour or so afterwards, the accident was reported to her. She then drives to the hospital. So she's nowhere near the accident.
Yes.
And then we see what happens. So it is not to do, as I understand it, with seeing or witnessing the immediate aftermath of the accident, that is, the cars strewn on the road, yes, etc. It is at the hospital. And if you go down then to page 595, paragraph 4, Lord Wilberforce specifying the immediate aftermath doctrine, he talks about the imperilment case, Baldwin-Sanderson. Then he says, in Marshall and Lionel, the wife came immediately upon the badly injured body of her husband. Again, no indication that this is to do with coming across the accident as such.
Yes.
And that is borne out by the facts of McLaughlin O'Brien.
Yes.
So it's not to do with the immediate coming across immediately of the accident.
No.
I think we need to be absolutely clear about that.
I agree with respect with my Lord Burrows. There is no magic about the word accident. It is not a necessary ingredient of these sorts of claims. The breadth of the claims that may be advanced, I submit, is ably described in Lord Oliver's element that there must be witnessed death, injury, or impairment. And whether that arises out of witnessing an accident, the immediate aftermath of an accident, an event internal to the primary victim, is of no consequence. What is being compensated by the law is the perception of that death, injury, or impairment within the mind of the observer, subject only to control mechanisms which, as my learned friend will point out, are extremely restrictive and onerous.
But do you accept there still has to be something shocking about what happens which excludes spouses and parents who suffer psychiatric injury as a result of the death or serious injury of their loved one, or seeing them in hospital linked up to the monitors and that kind of thing? That is shocking in the ordinary sense of the word, and it may in fact result in psychiatric injury. But do you say that the law goes that far?
I don't say the law goes that far, and in that regard I don't necessarily defend the law. There are good arguments to be made that someone who spends their life caring for a grievously injured loved one and suffers psychiatric injury as a result should be entitled to recover.
No, I'm not talking about that. I'm talking about the immediate shock of seeing your loved one all bandaged up and bruised and linked up to a respirator or something. Again,
I don't defend the position that the loved one may not be able to recover, but that's the way the law is. And the law, in the clinical negligence context, has said that the relevant event must be horrifying. That's Swift J in Shorter, Tomlinson LJ in Renane. And against that background, it must be objectively horrifying, per Swift J in Shorter. And the implication of that is that if one comes across a situation which my Lady Rose envisages, of seeing someone bandaged up on drips and all the rest of it, it is distressing, it is arguably shocking, it can cause psychiatric injury, but it's not objectively shocking enough to enable recovery in this situation. Because as Lord Justice Tomlinson said in Renane, and I paraphrase, if one goes to a hospital, one is prepared for illness and sickness, and one cannot therefore argue necessarily that the event they perceive is immediately shocking, because there's been an element of preparation for that. But I don't say that the distinction that my Lady Rose draws, unhappy as it may be in some situations, makes this cause of action unworkable. The essence of what I say is that this cause of action is a code which may readily be applied by judges, just as any other cause of action in the law of negligence may be, by reference to relevant principles. And the code is the control mechanisms and whether the horrific event or the event is sufficiently objectively horrifying.
Because just seeing a loved one linked up to machines and all the rest of it is not an event. In your case and the case in Paul, there is an event.
Yes.
In the Paul case, a very striking one, and I've just been looking at the facts in your case as well, and they would constitute an event.
Yes.
That's really the nature of your case, isn't it?
Yes, it has to be.
Something needs to happen.
Yes.
And it needs to be shocking in the sort of objective sense.
Yes.
And you say what you don't need is some other event which has led to that injury. That's in a nutshell your case.
Exactly, and the fact that
speaking for myself, I find it extremely difficult to get that out of Alcock. But that's not really the point. The point is whether the law should now recognise the sudden death, as in the tragic case of Paul, as being an event which should give rise to recovery for those who are psychiatrically injured by it.
I would go further and to accept, my Lord, that the event has to be readily discernible, as well as being horrific, and hence the debate in Walters over whether the 36 hours qualified. But even...
And actually the aftermath principle is in a sense an exception to what I've just put, because it's the fact that you come across the catastrophic situation with your loved one lying there dead,
yes,
that allows you to recover, because the event,
yes,
is both the catastrophe and the immediate aftermath.
Well, I would say the event in that scenario is the immediate aftermath, and
well, yes, but by using the word immediate aftermath, you're already linking it to
yes,
something which has happened. And I think that the trend of the cases is that you can't separate it from what has happened.
Yes, and as was said in Benson and Lee, which was approved by Lord Wilberforce in a passage which we cited many times, the facts and consequences of the breach of duty can be one of a series of events which go to make up the happenings as a whole, and so long as a discernible horrific event can be discern from that, and that's a judicial function which is readily deployable, then there's recovery. I'm conscious of the time, and I do move on to deal as briefly as I can with the question of whether there is a need for an event external to the primary victim, and I say no, and that the suggested authority for that, Taylor and Somerset, is unreliable in that regard. It will be remembered that what the claimant was arguing in Taylor and Somerset was that he didn't have to, or she didn't have to discern any particular type of event at all, so long as there was an event, her husband's death, which caused the shock, that was sufficient. And it was against that background that Mr. Justice Auld said, well, no, hang on, there has to be an external event. And in doing so, Mr. Justice Auld quoted from Lord Ackner's fifth proposition in Alcock, saying that there had to be a sudden horrifying event operating on the, or causing, violently agitating the mind. And I say that Mr. Justice Auld extrapolated from that perhaps a bit too far in saying that what was required was an event external in some regard. Now, some people say that he was suggesting that there should be an event external to the primary victim rather than an event external to the secondary victim. I say that he didn't go that far, and it was the analysis of Mr. Justice Chamberlain in Paul, for later reference, if relevant, 343, paragraph 72. It was the analysis of Mr. Justice Chamberlain in Paul that what Mr. Justice Auld was talking about was an event external to the secondary victim.
Such as what? I find that...
Well, such as not being told that the husband had died at work when she went to hospital. That was said not to be a sufficiently external event. What I submit Mr. Justice Auld was searching for was a event that could be perceived rather than news that could be delivered. And it was on that basis that he dismissed the claim. And his words don't go sufficiently far to say that what was required was an event external to the primary victim. For Mr. Justice Auld to dismiss that claim, his lordship did not have to go that far. It was sufficient for Mr. Justice Auld to say, well, hang on, you haven't actually witnessed anything. You've just been told about your husband's death at work. You have seen him in the mortuary, tragically deceased, but we know from Alcock that that is too far beyond any conception of qualifying event to qualify. And so that really was what Somerset was about. It was not part of the immediate aftermath, and it was not sufficiently shocking to amount to a horrific event. And I refer my Lord and Ladyships to the relevant paragraphs. I am conscious of the time. paragraph page 1310, please. Sorry, 1301. I'm grateful. So the arguments advanced by the defendant in that case, which were both accepted by Mr. Justice Auld, were firstly, the second paragraph down, that the death, however unexpected and shocking to Mrs. Taylor when she learned of it, was not in itself an event of the kind to which the
Sorry, where this is on page 1301.
Yes, forgive me, my lord. Second paragraph down.
What, Mr. Hart submitted that paragraph?
The one above that, my lord.
Oh, I see.
So halfway down that paragraph, it was said that the death was the culmination of a natural process of heart disease, and however unexpected and shocking when she learned of it, was not of itself an event of the kind to which the aftermath extension can be attached. So what his that argument was accepted. So what his lordship...
He maintained the test required some external traumatic event in the nature of an accident or violent happening.
Yes, indeed, and that was lacking in that case, and I accept that. But I don't say. Well, I say that Mr. Justice Auld was not saying that there must be an external event to the primary victim.
There, he's just recounting the submissions of Mr. Hart.
Yes, but fourth paragraph down, my lady, he says that Mrs. Taylor's claim must fail for both of the reasons advanced.
He does say the death was not in itself an event of the kind to which the immediate aftermath extension could be attached.
He does. If that is taken as a requirement that there must be an event external to the primary victim, I say, A, it's obiter, because it wasn't necessary to make that finding to dismiss the claim,
yes,
and B, it is an inappropriate
I mean, it's difficult to say it's obiter when the judge says that these are the grounds for his decision. It may be wrong, but it's difficult to say it's not part of the ratio. I mean, you're providing an alternative explanation. That doesn't mean that the reasons the judge gave were obiter.
Perhaps not.
And anyway, why does it matter? Because Lord Dyson in the Taylor and De Novo case approves that clearly as part of his ratio.
Yes. I'll come on to Novo. What I say about Somerset in that regard is that if his lordship was finding that there must be an event external to the primary victim...
Well, he clearly was. I mean, the submission he accepts was that it was the culmination of a natural process of heart disease and didn't involve any accident or violent happening.
Well, if that was his finding, that was with respect wrong, because there was nothing in the speech of Lord Ackner to support that. Moving on to the case of Novo, and I am conscious of the time. Page 636, please.
I'm so sorry, page?
636, my lord.
Thank you.
Paragraph 29. Second half of that paragraph. The ratio of that case is arguably quite narrow. It said, moreover, if Miss Taylor had been in physical proximity to her mother at the time of the accident and had suffered shock and psychiatric illness as a result of seeing the accident, she would have qualified as secondary victim on established principles. Arguably, the ratio is simply that an earlier qualifying event an earlier horrific event bars recovery for a later horrific event.
Yes.
But the wide...
That's a nonsensical rationale. Well, the one that makes sense of it is that you recover if what you see is an accident, somebody being injured in an accident, but not if at some later time, whenever it may happen to be, you just see them suffer. I say just, it may be a very traumatic thing, but just them suffering an injury and dying.
Yes, and
such that somehow you recover for the death if there's no prior accident, but not if there is one, which just seems completely...
Although it's possible to have two horrific events deriving from the same breach, but that I accept that's far-fetched. If the ratio is as my Lord Legate identifies it, then I say with respect that Lord Dyson fell into error in making that finding. And I say so on an analysis of the claim being advanced by the defendant, which was accepted wholesale, if I can put it in that way, by the Master of the Rolls. Paragraph 20, page 635. Mr. Corey Wright, QC, counsel for the defendant, submitted that it was incorrect to elevate proximity to a relevant event so as to be a test. So what he was saying is that mere physical proximity to that second event was not sufficient to satisfy the legal proximity test. I would accept that because other control mechanisms have to be made out. Then Mr. Corey Wright went on to say that the correct question is proximity between the tortfeasor and the secondary victim, and then the focus of the inquiry was on proximity to the first event, and there was no physical proximity to that. And then the Master of the Rolls then seemed to run with that and said at paragraph 28 on page 636, I accept the submission of Mr. Corey Wright that the correct question is whether Mrs. Taylor and Novo were in a relationship of proximity in the legal sense. And he concluded in paragraph 29 that because she was not physically proximate to the first injury, she was not legally proximate to the second injury. Now, through that, if I can use this phrase with the greatest of respect, somewhat circuitous route, the actual control mechanisms which define legal proximity were completely ignored, because nowhere in Novo did the court ask itself, was there a horrific event in the second event? Was the claimant proximate to that? Was there a close tie of love and affection? Was it directly perceived? And had those questions been asked, the answer would have been yes to all of those, and legal proximity would have been established. And insofar as Lord Dyson ignored those control mechanisms and focused simply on physical proximity to the first accident, with respect, his lordship fell into error. And I submit that the decision was supported on further grounds which were not correct. At paragraph 30, it was said it would be very unfair if a claimant missed the immediate aftermath of a first accident by a short time, and yet was able to recover for a subsequent horrific event many months later. And he said that would be an unfair situation. I say that that's entirely understandable under the current control mechanisms, because in that situation, by definition, the primary victim, the secondary victim is by definition not witnessing a qualifying event in the first instance because they missed the immediate aftermath by a short time, but by definition they are in the second instance because it's horrifying and all the rest. The other ground upon which the argument to dismiss the claim was supported was on grounds of policy. And the Master of the Roll said, I take into account the thus far and no further speech of Lord Stane, and I accept for policy reasons that this doctrine should not be expanded. My learned friend, Mr. Pitchers, will address the court on why those policy reasons are unpersuasive and don't stand up to analysis. But in addition, the Master of the Rolls' attention was not drawn to the Ministry of Justice's response paper, which said that development of this area of law on the facts should be left to the court and not Parliament. And that renders, in my submission, somewhat irrelevant the concept of the master, the comment of the Master of the Rolls that this should be left to Parliament to develop any further. Lastly,
are you actually asking us that? I mean, clearly the Court of Appeal felt that they would have to have, they were bound by de novo.
Yes.
In other words, it would have to be overruled
Yes.
by this court.
Yes.
Is that ultimately your submission, that we need to overrule de novo?
If my Lord Legate's conception or analysis of the ratio is correct, that would have to be...
right. So you are here differing from Mr. Weir's submission?
To some extent, yes.
I mean, it's the issue in paragraph 25.
Yes, my Lord.
Is stated by the Master of the Rolls to be whether the death of Mrs. Taylor was a relevant incident
Yes.
for the purposes of Ms. Taylor's claim as a secondary victim.
Yes.
So really, you've got to say it's wrong, haven't you?
If it was, the claim would succeed. So.
Yes.
Yeah.
If that's the case,
Well,
yes.
that's what he says the issue
Yes,
was.
my Lord. It's wrong in the sense that he said there's an existing accident which has caused a later consequence, and if that is used against us in this case to say that the previous breach of duty led to a later consequence, and that can't survive novo, then I submit novo must be wrong.
Yes, I see the distinction.
But on my more narrow interpretation of the definition of novo, or the ratio of novo, that an earlier event, horrific or otherwise, disqualifies recovery for a later consequence, we don't necessarily fail because there was no earlier event in this case. Lastly, my lords and my lady,
how can you be better off if there's no earlier event? I just don't understand why that's. I mean, it may be neutral, but why is your case improved if there's no earlier event?
Well, it improves if and insofar as the court attaches any significance to an earlier event. I say it shouldn't, but if the court does, then clearly it assists my case that there is no earlier event in my case. But I say that if the court...
well, the reason why we might attach significance is we might think that was necessary, that there be an event which is witnessed.
Yes, and I would...
So it won't be better off if there was never any event at all that was witnessed. Or even could have been witnessed.
Well, that goes to the nub of the appeal, my lord. I say that...
It does go to the nub of the appeal.
Yes, I say that there is... which is... and it's perhaps good that my lord raises it at this stage. Well, I say there is no need for an earlier event or of any description. What there is a need for is a conception in the mind of the secondary victim of death, injury, imperilment.
And it doesn't matter if the death-causing event is wholly internal.
It doesn't matter, no.
And the result of an omission by the doctor to diagnose.
Yes.
And depends upon some life-threatening condition which the person may have had from birth, for all that knows.
Indeed. My Lord's last comment about some life-threatening condition that occurred from birth.
Well, it's not diagnosed, and therefore causes a death which could otherwise have been avoided by treatment.
Indeed, and the horror of that situation has been created by the breach of duty,
yes.
And that is the essence of these causes of action.
Yes, sure.
And the fact that it was a natural condition is irrelevant, because if that horrific event could have been prevented by the breach of duty, then we succeed, I say.
There may be no realisation of that, of course, at the time. It's just the same for the person who experiences it if there had been a missed opportunity negligently to diagnose, or if there hadn't.
Indeed.
But once you discover afterwards, you say, through analysis, that there was a negligent failure to diagnose, that brings not only the death itself, but the psychological consequences to others within the scope of duty.
That's the same in any clinical negligence case. When there's a suboptimal outcome at hospital, the victim doesn't know until it's been looked into whether they're...
That's when there's no issue as to legal proximity.
So you're saying that one of the control mechanisms is that for secondary psychiatric injury, there is one event per negligent conduct. Otherwise, it's just too expanded. And if that event is the original accident, then that is the event to which the secondary victim has been proximate, and then any subsequent events don't count. If there's no accident and the first event is the collapse, death, whatever, of the primary victim, then the secondary victim can be proximate to that. But if they're not proximate to that, then whatever happens afterwards is irrelevant. And that is a somewhat arbitrary control mechanism.
I don't say that one is shut out if there's been an earlier horrific event. And to that extent, I echo my learned friend Mr. Weir's analogy to the burning building. Several people can be affected by various events within the burning building scenario. The fear of a loved one dying who might ultimately be unscathed, that seeing a loved one jump out the window. If they satisfy the control mechanisms, they all recover. Where I might differ from my learned friend is that I say that is possible in a internal to the primary victim scenario as well, in theory. But in reality, in clinical negligence, it's highly unlikely to arise. It's highly unlikely in clinical negligence that there will be successive horrific events. In theory, if there are, then in theory there might be recovery. But there are other control mechanisms which prevent that, such as Lord Justice Tomlinson's statement in Renane that if it happens in hospital, it may not necessarily be horrific. And it's difficult to conceive of those situations arising very often at all. They'd be exceptionally rare. And that possibility should not undermine, in my submission, the validity of this cause of action.
It's not rare that somebody who has a heart attack or a stroke, which they survive, then a few days later has a heart attack and a stroke from which they die.
Yeah.
That's not uncommon at all.
That's not uncommon. It would be exceptionally unlikely for there to be numerous claims arising out of that, because whoever witnessed these horrific events would have to be in physical proximity and satisfy the other control mechanisms. It's easy to conceive of difficult cases which undermine the doctrine as a whole, but that doesn't lead to a case for abolishing the cause of action as a whole. That would be wrong.
Mr. Ty, we're up against your deadline.
Yes.
Largely due to our fault in asking you questions, but your answers have been of great assistance.
I'm grateful.
If there's anything you want to say shortly that isn't in your written case, by all means do, but otherwise I think we must
yes, we must move on. My last point is a very concise one, I hope. Paragraph 35 of Walters, page 665, is construed by my learned friend Mr. Weir as an indication that the test applied there was when damage first became manifest. I say that the manifest damage case control mechanism is completely unprincipled. The words to which my learned friend attaches significance is it is a useful metaphor event, that is, or at least a convenient description for the fact and consequence of the defendant's negligence per Lord Wilberforce, or the series of events which make up the entire event, beginning with the negligent infliction of damage through to the conclusion of the immediate aftermath, whenever that may be. What my learned friend says is that the words negligent infliction of damage mean that the court is searching for the first manifestation of injury, and that means that supports his case for the manifest damage control mechanism. That is not correct, and is completely contradicted by the fact that the court did not make any inquiry at all into the fact or otherwise of manifest damage to this very sick child before the 36-hour horrific event. The facts show that he was admitted to hospital in a very grave condition on the 26th of July. The horrific event started on the 30th of July, but no inquiry was made into what sort of damage he was manifesting before. And the words that my learned friend, or the significance my learned friend attaches to those words, are completely undermined by the next paragraph, or the next sentence. It is a matter of judgment from case to case depending on the facts and circumstances of each case.
Yeah.
So negligent infliction of damage in one case may not be the relevant event in another. It completely undermines the case for the manifest damage control mechanism. The whole inquiry there was on whether it was horrifying or not, which is as it should be in a clinical negligence case involving an internal event to the claimant, and that is underlined by the conclusion at paragraph 37. My learned junior will not take more than 10 minutes if...
Well, that's going to take you way over your...
Yes. My learned friend, Mr. Pitchers, has said that he can take 15 minutes off his submissions. We agree with each other's submissions.
Well, with Mr. Pitcher's indulgence, that could be permitted. Thank you very much, Mr. Pitcher.
We have discussed this in advance, and I'm grateful for the court's indulgence.
Yes.
My lords, my lady, I won't keep you for long, which will be a reassurance to everyone, I'm sure. I'm going to provide a brief summary of how the facts of Mrs. Purchase's case fit within the various proposed frameworks. I start with a reminder, no doubt none being needed, that a claim should not be struck out, and we are talking about strikeouts here, unless, and I quote the only relevant basis, the statement of case discloses no reasonable grounds for bringing the claim, and summary judgment should not be given unless the claim has no real prospect of succeeding and there is no other compelling reason. A second brief reminder, in order for a duty of care to be owed where a claimant has developed psychiatric injury induced by shock, a sudden appreciation by sight or sound of a horrifying event, to use Lord Ackner's words, they need to show 1, reasonable foreseeability, and 2, legal proximity. Reasonable foreseeability is not an issue on these appeals. That was confirmed by Mr. Maskery yesterday. The question of whether there is legal proximity, per Donoghue and Stevenson, is the claimant so closely and directly affected by the defendant's act that he ought to have the claimant in his contemplation as being so affected when directing his mind to the acts or omissions in question. That is answered by satisfaction of the control mechanisms. I briefly review the facts. The claimant took her sick daughter to the out-of-hours GP. We say, and it's not an issue for the purpose of the appeal, he conducted an inadequate assessment. He fails to recognise key signs and symptoms of severe pneumonia. He wrongly diagnosed depression. He gave inadequate and inappropriate advice, including discouraging them from attending hospital. Mother and daughter went home together, and Evelyn remained at home sick. I'm conscious as I continue that our client is watching these proceedings on the live stream. 2 days later, the claimant left her still sick daughter at home for the evening, not alone, but with husband in the house. When she returned in the early hours of the morning, she went to her own bedroom, and there she found Evelyn lying, telephone in hand, staring at the ceiling, not moving. She touched her. Evelyn's skin felt warm. She looked alive, but she was not blinking or moving. Mrs. Purchase started to panic, and she started screaming hysterically. Evelyn's younger sister came in and started screaming hysterically. Evelyn's father came in and started screaming hysterically. The claimant got Evelyn onto the floor to give her CPR. She realised Evelyn had urinated on the bed. As she opened Evelyn's mouth to give her mouth-to-mouth resuscitation, blood and bodily fluids spilled out. She tried desperately to resuscitate her daughter until paramedics arrived, increasingly aware that her efforts were in vain. The paramedics arrived, and she watched as they used the defibrillator to try to shock life back into her beloved daughter. After a few minutes, the paramedics said there was nothing they could do. At that point, the claimant realised she had a voicemail from Evelyn on her telephone. She listened to it. It was Evelyn's dying breaths, continuing for 4.5 minutes, the phone call finishing literally minutes before she had walked into her bedroom and found her daughter on the bed. Mrs. Purchase ran into the street screaming hysterically. She was ushered back inside. She sat with Evelyn's body, afraid to cuddle her. She watched the body being taken away. She then tried to scrub away the blood and the bodily fluids from the floor of her bedroom. and as a result of that experience, she developed post-traumatic stress disorder. Before I address you on the control mechanisms, I will turn briefly to whether this is a pure omission case. The summary of the alleged breaches that I have just given shows beyond doubt that it is not. There are numerous positive acts criticised, as well as some acts which can be characterised as omissions. Those characterisations as omissions are not pure omissions for which liability is restricted in law. Turning to the citation of Stovin and Wise in the case of Robinson at page 1210H. Is this about how an activity was conducted, or is it a case of imposing a duty to act on someone who was not carrying on any relevant activity? It is very clearly a case of the former. So this is not a pure omission case by any stretch. Even if it were, there are various legal bases for imposing a duty in cases of pure omission, for finding legal proximity, and one of those is satisfaction of the control mechanisms, and that was made clear in the case of JD. So that then brings me on to the control mechanisms, and I start by going back to basics. The original control...
Sorry, which case were you referring to?
The case of JD, the one that was handed in very late,
yes,
just before the hearing started yesterday morning, and it's paragraphs 107 and 133, where they confirm that there is a duty of care on a doctor to a secondary victim, including, and the example that they directly give is where a doctor negligently fails to carry out a caesarean section. Now, that would be closer to a pure omission than anything in Mrs. Perch's case. But we would still probably dispute that that was a pure omission, but I don't need to go into that. So the basic control measures, as summarised by their lordships in white, in near identical characterisations by all five of their lordships, reflecting Lord Wilberforce's three inherent elements in McLaughlin, Lord Ackner's three elements in Alcock, and summarising Lord Oliver's five common features. Firstly, did Mrs. Perches have a close tie of love and affection with the person killed, injured, or imperilled? There can be no dispute that as Evelyn's mother, she fulfills that criteria. Was she close to the incident or its immediate aftermath in time and space? The incident, of course, being Evelyn's death. It could otherwise be an injury or an imperilment. She was at the scene within a matter of minutes, so yes. Thirdly, was her psychiatric illness caused by the direct perception of the incident rather than hearing about it from a third person? Yes, she witnessed that horror with her own eyes. She was the first to find Evelyn. It was obviously sudden and horrifying and shocking, which are the different words that the court has used in demanding the type of event. And yes, it was that which triggered her illness, that perception of that horrifying event, triggered her post-traumatic stress disorder. So unless further restrictions are added to these original control measures, the claim fulfils the criteria.
Sorry, just want to be clear. How many are you specifying?
Three.
Three.
Three is the number that's been used universally.
Right. So you're rolling into, was it direct perception?
That's the third, as given in all of those characterisations.
Where's the horrific nature, the shocking element?
The shocking element is a precursor to all of that, because these questions are only asked, as per Lord Ackner, where somebody has developed psychiatric illness as a result of shock, and then he defines shock as the witnessing of a horrifying event. Would you like the reference?
Yeah. I mean, I think an alternative way of putting it, if I might suggest, is just that there is an added element of shock, shocking, that the event in your analysis, the death, has to be shocking.
Indeed. So the way Lord Ackner puts it, even though the risk of psychiatric illness is reasonably foreseeable, the law gives no damages if the psychiatric injury was not induced by shock. And then he goes on to follow that with shock in the context of this cause of action, i.e. psychiatric illness caused by shock, involves the sudden appreciation by sight or sound of a horrifying event which violently agitates the mind. And then it was Lord Oliver who characterised that horrifying event as the death, injury or imperilment. That must be the cause of the psychiatric illness.
But are you or are you not accepting that that is a separate element that must be established over and above the fact that what happened caused psychiatric injury?
There's different ways of characterising it. One can either say it's a precursor to the entire cause of action, that the psychiatric illness is caused by shock, by perception of a horrifying event. And so you first of all consider, has the claimant witnessed a horrifying event? And then you apply the control mechanisms to that horrifying event. Or you can say the claimant has suffered psychiatric injury. Does she satisfy the control measures? And also it must be horrifying in the objective sense of the word.
I have to say, I find the latter of those much easier to understand myself.
And I don't demur from that, my lord. So this claimant, Mrs. Purchase, clearly satisfies all of those requirements, and perhaps if I put it in that slightly more neutral terminology, those requirements, the three set out by numerous of their lordships, and the requirement for it to be objectively horrifying, in the same way as a road accident could be objectively horrifying and somebody's death therein, or indeed a disaster such as Hillsborough. And whilst I wouldn't want to get into a hierarchy of what is horrifying, it is clear that it needs to be very horrifying, which was why Renane failed.
Yep.
But is there, if we're looking at the criteria for what makes an event, a horrifying event for this purpose, what guidance is there other than it's not enough just to see somebody in hospital suffering?
So I think the guidance from Renane that it must be objectively horrifying in the mind of the reasonable and sort of the normal person, that's the sort of concept that the courts are well used to applying, objectively horrifying, not subjectively with reference to other criteria, but objectively. And certainly in practice, I know I've had cases where I've had to advise a client what you suffered was unbelievably distressing and it will stay with you for the rest of your life, but the court will not see it as objectively horrifying. It's just not bad enough, which is never a nice conversation to have with a client.
But are they clients who've proved that they've got psychiatric illness, as opposed to just, I'm not meaning to minimise it, but mental distress and anguish short of being a classified psychiatric illness?
No, severe PTSD.
Severe PTSD, and there are then, the advice has to be, you're not going to win because what you saw was not sufficiently horrific for legal purposes.
Indeed.
All sudden.
Indeed. Sometimes it's the suddenness.
I'm thinking of the father who sits for 14 days with his dying son.
Absolutely.
Plainly could cause PTSD, but it's not sudden.
There's no sudden impact on the senses, which was what the court was considering in Walters, and finding that you can't have a gradual accumulation. It must be a sudden impact.
Yeah.
Or you can have cases, of course, where it wasn't physically witnessed by the parent, let's say, but it was such a horrifying event, and they told about it and think about it, it causes psychiatric
Indeed.
injury.
And that's explicitly ruled out by the control mechanisms.
Yeah.
I'm very conscious of time. I'm running into Mr. Pitcher's precious time.
It's been very helpful.
A couple more points, if I may, and I will whiz through them briefly. If there is an additional restriction that it has to be the horrifying death has to be the first manifest damage, as contended for by the respondents, well, here there was no manifest damage. Evelyn was ill. She remained ill. Nobody could have known that there was additional damage caused by the lack of care of Dr. Ahmed until the moment when Evelyn took that terrible, terrible deterioration. And indeed, the way the claim is pleaded in terms of the causative pathway, maybe if Dr. Ahmed had done his job, they would have gone straight to hospital.
Yeah.
But the alternatives are that they would have gone home and they would have stayed there. They might have gone to hospital at some point over the following 2 days, We don't know then when antibiotics would have kicked in, but there would have been a further delay there. Or simply Mrs. Purchase wouldn't have gone out that night and she would have stayed there at Evelyn's bedside. She would have recognised that things were taking a terrible, terrible turn for the worst, called the emergency services, and so in fact it's not until the start of that horrifying event that things would have taken a different path. So if it's first manifestation of damage, we get home on that one. If there's an additional restriction that there mustn't be an earlier event or an earlier horrific event, there was no such event here. There was a consultation at the doctor's and then Evelyn sick at home in bed for 2 days.
Yeah.
Turning finally to the respondent's characterisation of the law, and very briefly, if there's an additional restriction that the horrifying event must involve a trauma external to the primary victim in the nature of an accident, then there was not here. We accept that. That would be the case in nearly every secondary victim case arising out of clinical negligence. It is impossible or near impossible to conceive of any clinical negligence that could be characterised as being in the nature of an accident. However, the basis for their submission that you must have that sort of event seems to lie in their assertion that there must be a relationship in the layperson's sense of the word, rather than the legal sense of the word, between the defendant and the secondary victim, an implication that the defendant must have this particular claimant in their contemplation in order for there to be legal proximity. Hence the reference to, well, what about an unborn child? Of course you can have proximity to an unborn child. They can be within the class of people to whom a duty is owed. An implication from the respondents that there must be physical proximity between defendant and secondary victim in order for there to be legal proximity between them. Well, Mrs. Purchase had such a relationship with Dr. Ahmed. She attended the consultation. Dr. Ahmed asked questions of her. She spoke to him on Evelyn's behalf about Evelyn's condition because Evelyn was too sick to do so herself. Mrs. Purchase was physically proximate to him at the time of his breaches of duty. It could not possibly be said that Dr. Ahmed would not or should not have had Mrs. Purchase in his reasonable contemplation as someone who could be closely and directly affected by his acts. So there is very obviously legal proximity between Mrs. Purchase and Dr. Ahmed, according to the test set down in Donoghue and Stevenson. So we wholly dispute the respondent's contention that further restrictions are needed in secondary victim claims, but if they are, such restrictions should not exclude this claimant who so obviously satisfies the Donoghue definition of proximity and indeed the control mechanisms as formulated in those three elements. And equally, if there is a flexible test, as now seems to be contended for on behalf of the Paul claimants, balancing all the different factors into account, balancing the various control mechanisms, again, for those same reasons, obviously, Mrs. Purchase should satisfy that test. I'm very grateful, thank you, and I'll hand over to Mr. Pitchers.
Thank you very much. This might be a good moment for the 5-minute break.
Yes.
Unless you want to have 10 minutes at us before we pause.
Entirely in your lordship's
and I think
ladyship's hands.
It probably makes sense to do it now, give you a clean run then through until lunchtime.
Yes.
Yes, Mr. Pritchard.
My lords, my lady, I appear on behalf of Mr. and Mrs. Polmear, the parents of Esme, with my only junior Mr. May. There may be some pros and cons to being third on the indictment. I hope that I can start by assisting this court with a distillation of what is and what isn't in dispute. And also I'll be able to avoid repetition of submissions you've heard, some from Mr. Weir, but also from Mr. Type, which I can adopt and endorse. My lords, my lady, all parties agree that to be successful, a claimant must have suffered a recognisable psychiatric injury. And that's not in dispute for the purposes of this appeal. Secondly, it's agreed that that psychiatric injury must be reasonably foreseeable, and again, that is accepted. Thirdly,
it's accepted that it was in this case.
It is accepted for the purposes of this appeal, yes, that the injuries were reasonably foreseeable. Thirdly, and it does seem to be a distinct requirement, the psychiatric injury must have been induced by shock. My lady, you raised comment in this respect just before the short break, and it may be worthwhile to look at page 563, Lord Ackner's judgment at paragraph, in Alcock at paragraph F, paragraph numbered 5, because this may be the best encapsulation as to what is required in terms of shock.
567, did you say? 3. Sorry.
563. And it's number 5.
What we were just saying a few minutes ago.
Yeah. Yes. And this is the best articulation. Sudden appreciation by sight or sound of a horrifying event which violently agitates the mind. My lords, everyone accepts that there must be legal proximity for a duty of care to be established. There is large agreement, it seems, that the 3 control mechanisms, save for what the definition is to a qualifying event perhaps, are the applicable test: close tie of love and affection, proximity in space and time, and the means of communication. So that the major disagreements, it would seem, with the respondent relate to whether there is a requirement for an external event, be that an accident or otherwise. And as to the state of the law, I adopt the submissions of Mr. Weir and Mr. Tyack in that regard. The disagreement between these appellants and Paul is whether or not there should be some modification to the control mechanisms to introduce some sort of perhaps flexible version of the first manifestation of damage test. In terms of the areas that I wish to focus upon, I'll deal with the facts at the outset and how that might be relevant to the question of omission. But really, my submissions are more focused upon the second part of Robinson. Mr. Tyack's addressed you on whether the claims as we present them fall within the existing law. And to some extent, I'm anticipating that there may be a range of views on that and addressing you as to why these claims are fair, just and reasonable, and why the development of the law in this area by analogous increment would be appropriate. But those considerations are also relevant when hearing the submissions of Mr. Maskery, which we say would amount to a significant rowing back of the law as it currently stands, and perhaps are also relevant to the position taken by Paul and the justification for a test of first manifestation. If I may turn briefly to the facts of the case of Polmear, which you will not have heard anything about to this point. Although we have agreed facts, it's also, I would suggest, worthwhile to look at the particulars of Cain, which begin at page 406 in this bundle. And on page 407 begins the summary of events that give rise to these claims. And it's these events that give rise to the allegations of breach of duty. And in outline, Esme was only 6 years old when she was first taken to her GP, suffering with strange episodes of breathlessness which were lasting several minutes. And she was referred by the GP to the defendant's hospital and seen on the 1st of December 2014 by a paediatric registrar. And it may or it may not be relevant, depending upon the test that this court determines is applicable, to note that both claimants were present when she was seen by the paediatric registrar on the 1st of December. So this is not the date of the horrifying events, it's the date that she was seen. It's the first date where her medical attention went wrong. And the particular claim on page 407, running over to 408, sets out the clinical note of that consultation with the paediatric registrar. And at the bottom of 407, you can see that a working diagnosis was given of likely vasovagal syncope. And without giving medical evidence, my understanding that is fainting as a result of dropping blood pressure. But essentially, and in itself, a relatively benign explanation for the episodes. And you will see that a history was taken as one would expect. Examinations were performed that included an ECG, blood pressure monitoring, and so on. And the management plan was formulated, which was for Esme to have a 24-hour ECG tape, presumably the hope being that that would catch one of these episodes. So I pause to observe that this is a defendant, through its clinicians, who has actively taken on the management and investigation of Esme's condition and has made a positive working diagnosis. And it was then, following that plan, 21st and the 22nd of January, that Esme underwent the ambulatory ECG monitoring that essentially returned normal results. And those results were reviewed by a consultant on the 5th of February 2015, who confirmed his conclusions in correspondence with the claimants, of course not with Esme, she was only a young girl at this point. And his opinion was that the best explanation for the symptoms was that they were related to exertion, and nothing to suggest an underlying abnormality of her cardiac rhythm. So again, essentially a benign explanation for those symptoms. And of course, as we now know, in fact, Esme had a serious underlying condition, which was ultimately only confirmed after her death, of pulmonary veno-occlusive disease. So it's against that backdrop that the allegations of breach of duty are articulated and are set out in paragraph 17 of the particulars of claim. There were substantial admissions made by the Trust in relation to Esme's management. And at 411, particularly as a breach of duty, the first one is an allegation not of an omission, but of an error of commission in making the wrong diagnosis. So that's by the registrar diagnosing vasovagal attacks, which was incorrect, illogical, and inconsistent with the primary symptoms. So what we say, and this calls back to the passage from Stoven and Wise that Lord Reid and Robinson quoted. I'll give you the reference, it won't take you there necessarily. It's page 1210, and it's enumerated paragraph 69.5, which is the need to distinguish between regulating the way in which an activity may be conducted and imposing a duty to act upon a person who's not carrying out any relevant activity. So what we say is, in these circumstances, this is not an omissions case. There were positive steps that were taken. The Trust, the defendant, actively took on the management of Esme, and in no sound conceptual sense can that be categorised as a pure omission. Otherwise, I adopt the submissions you've heard already about the law relating to omissions. The events of the 1st of July, in my respectful submission, should be considered in order to bring some real-world context to the law that this court needs to apply, and particularly in order to consider and analyse what might be considered to be fair, just, and reasonable. My Lord, the Polmears live in Cornwall by the seaside. Esme's primary school is in the same town, and there was a planned school outing to the beach on the 1st of July. Now, Esme hadn't been feeling well that morning, and Mr. Polmear had agreed to pop to the beach to see her, to check on her, essentially. And she was unwell when he arrived. She was noted to be tired, pale, and breathless. So he carried her back to school, but because he had no reason to believe that she had a serious underlying condition, felt safe to leave her at school. But he was shortly called back because Esme had collapsed. So when he returned to school, he ran back to school, he found Esme lying on the floor with a member of staff providing first aid. And he actually took over the attempts to resuscitate Esme, attempting mouth-to-mouth resuscitation, but Esme wasn't breathing. Esme's mother also ran to school because she worked nearby and saw Esme on the floor and also witnessed the attempts to resuscitate her. And they accompanied her in the ambulance to hospital. Unfortunately, the attempts that continued to revive her proved to be unsuccessful, and Esme was 7 when she died. And I would suggest, not surprisingly, both claimants have been profoundly injured by these events. They've developed post-traumatic stress disorder and major depression. And of course, implicit in the admissions that we have from the defendant, and certainly for the purposes of a strikeout, is a proposition that this is not a death by natural causes, but an avoidable death. And these are avoidable, horrifying events which Mr. and Mrs. Polmear witnessed. My Lords, just setting the structure respectfully as to how we say the court should consider the competing arguments, and we squarely adopt Lord Reed's approach in Robinson, passages to which you've already been taken. And what follows from this is, if you agree with, largely so far, Mr. Tyack and Ms. Gamble, that our claims come with the law, within the law as it currently stands, we do not need to pray in aid concepts of fairness, justice, and reasonableness. But as I've indicated, if the defendants seek to divert the law from as it currently stands, they very much do need to justify that position by reference to those considerations. In the alternative, if you are not satisfied that a duty of care was owed to Mr. and Mrs. Polmear within the existing established law, well then inevitably we do invite the court to take what we would describe as a cautious and a conservative incremental step. And it's paragraph 29 of Lord Reed's judgment at Robinson 1198, to which you've already been taken, requires the court to look at the closest analogies in the existing law with the aim of maintaining coherence and avoiding inappropriate distinctions. And it's by that process that the court is best able to determine whether it's fair, just and reasonable to impose a duty of care. I adopt entirely the submissions that you've heard as to the need for flexibility and the caution against interpreting passages of judgments as if they were statutes. In fact, those are concerns I've heard echoed this morning in some of your Lordship's observations. Those judgments do not lend themselves to that sort of textual analysis. And that's a point for all of the advocates in this court to acknowledge. The perception of the ordinary reasonable person matters, as Lord Dyson said in Novo, and again you've been taken to that 637A, where he said, in this area of the law, the perception of the ordinary reasonable person matters. That is because where the boundaries of proximity are drawn in this difficult area should, so far as possible, reflect what the ordinary reasonable person would regard as acceptable. And we say that arises in two very closely interrelated ways. Firstly is that the court ought to avoid a result that may seem to be unjust or perverse. but also in terms of the reason for that result. The distinction should be logical and as coherent as possible. And, of course, it is my submission that for Mr. and Mrs. Polmear's claims to fail would be offensive to common sense. Particularly not just the fact of their claims failing, but if the reason that they were unsuccessful is not because the law doesn't recognise purely psychiatric injury claims, nor because the law doesn't recognise secondary victim claims, but because, for example, the law only recognises those claims if there's been an accident, if there's been some external event, or perhaps only if the event that was horrifying was the first manifestation of damage to the loved one. So we say the result, but also the reasons for it would be unjust. And
so you say that if one was to carve out a category, or you may have it put against you, it's already carved out, but in any event, recognising a category of accidents is to balkanise the development of the law.
yes,
It's just an island, self-contained island, but it's not coherent.
it's not coherent. It's not borne out in the established decisions. The points that were made to my friend Mr. Tyack, in a sense, also applied to the defendant's position here, which is one cannot find a clear articulation of principle that there must be an external event. At best, the cases just don't decide that question. But yes, if one were to accept that distinction, it would lead to those illogical results and that incoherent, we would say boundary. And perhaps that's why in the Court of Appeal below, the Master of the Rolls and Lord Justice Underhill, and it's a unanimous decision, both said, to paraphrase, that if the matter was free from authority, they would see why these claims should be successful. And the references are 294G2H for the Master of the Rolls and 313C for Lord Justice Underhill. And in one sense, by taking this court through the circumstances leading up to Esme's death, in many ways I've made almost all the submissions I need to establish why the ordinary reasonable person would consider that these claims should be successful. In addition to the point that this was a completely avoidable death, and this may be relevant when the defendant says the court should look more broadly at proximity and what was in the reasonable contemplation of the tortfeasor, is to reflect upon the claimant's direct involvement in Esme's medical management. Because, of course, as parents of a young child, it was them who was, upon whom Esme was reliant to seek out medical attention. She had no realistic means of seeking it herself. They have parental responsibility for her. So legal duties as well as obviously a moral duty to take care and look after their daughter. And they are present at the only face-to-face consultation when Esme is seen. So there's no point in this timeline where Esme has independent medical care, somehow unconnected to her parents. And then they're both present when they are forced to witness really unimaginably horrifying events involving her collapse.
Can I just ask you something, Mr. Pitchers,
yes.
in that regard? I can understand that proposition,
yes,
that where there is that kind of direct involvement in what effectively is the precipitating event,
yes.
then there ought, as you say, to be liability in that limited set of circumstances. But if you're making that as a submission, what do you say about the situations where that is not present?
Well, my submission is that is not that is the test, that there needs to be proximity to some earlier event, and that's because I endorse all of the reasons that have been advanced by Mr. Weir and Mr. Tyack. It's really, I suppose, an additional observation in terms of a broader analysis of proximity and reasonable contemplation to say, in fact, for these claimants, and we don't put this forward as the threshold test, but in fact for these claimants, they also have that very direct involvement with all aspects of Esme's dealing with the defendant trust.
Thank you.
I mean, if we were to think about the law's concept of assumption of responsibility,
yes,
does your submission then say, well, at least on these facts, your case, there must be an assumption of responsibility to the parents
yes,
as well as to Esme? Is that what it boils down to?
Well, we don't say that's a necessary requirement for there to be a successful cause of action. In fact, if in our secondary or tertiary positions, the court concluded that there needed to be an assumption of responsibility, not just to the primary victim, but to the parents, and we would say yes, in these particular circumstances, that there is that assumption of responsibility when one considers a doctor treating a child whose parents are present and involved in their management. But that's very much a fallback.
I mean, if the doctor had been called to where she was at school and the parents had not been there,
yes,
that makes it a very random connection. I mean, nothing upsetting actually happens at the consultation.
No.
I mean, isn't your alternative way, a way, if it's correct, a way which dispenses with the need to be a secondary victim? Because if a duty of care is owed directly to the parents for their welfare, then it's a direct claim by them.
That would be a much broader duty, I suspect, and one would be more difficult to establish than the route of secondary
It's not
victim.
the case that's being put, is
It's
it?
not the case that's being
No.
Because if it was being put, it might, at least in theory, attract a much wider range of responsibility
Yes.
for injury.
Yes.
And there are cases like that, aren't there, where, well, I was reading a case about a prisoner who was put in a cell with somebody who commits
Yes.
suicide, for example,
Yes.
and suffers trauma, but there they were covered on the basis of they shouldn't have put him in the cell because he was a particularly vulnerable person, I think.
Yes.
So a duty was owed directly to him, and there was a breach and
Yes.
consequence. But all these cases are put before the court on the basis of secondary victim cases.
Yes, and I should be clear, if I wasn't sufficiently clear, that these extra factual matters involving the Polmears are not what we say are the test and why they're successful. It's, in a sense, an insurance submission, which is, even if you're against us on the law and that the incremental step shouldn't be taken, if you take what seems to be the way that Mr. Maskey formulates things in writing and look more broadly at proximity, if I can ask a rhetorical question, in what sense can it be said that Mr. and Mrs. Polmear were not in the reasonable contemplation of the doctors who treated Esme? But that's not the test that we say applies. My Lord,
The trouble is that the direct application of the Donahue and Stevenson test is a shark-infested minefield, and that's
Yes.
why all these other ways of getting to legal proximity have been developed.
yes, and the control mechanisms are, I would suggest, the codification, the informal codification of proximity in the sphere of secondary victims.
Yes.
The law has developed the control mechanism to say, well, if you ask these questions, you'll have the answer at least on proximity.
You tick the legal proximity box.
Yes.
You don't go direct to the Donahue and Stevenson
Yes.
statement, save that it illuminates
Yes.
what the control mechanisms are there for.
Yes.
Yeah.
And an extension of that position is we say that there isn't some extra general consideration of proximity that the court can apply on top of control mechanisms.
No.
That would be an extension of the law.
Yeah. And there's plenty of authority against that.
Yes.
Yes.
My Lords, the defendants in their written case put the opposition to the position of Purchase and Polmear rather high, and we say mischaracterise our position. And at paragraph 11, page 256, it's put this way. It said that the effect of the appellant's arguments, and for these purposes I will treat that as the Purchase and Polmear arguments, suggesting it's insufficient to be present at the consequence alone or its immediate aftermath, is in reality to revisit those arguments rejected in Alcock. And of course, in Alcock, the argument was that all that was required was reasonable foreseeability, and our position is nowhere near that submission, nowhere near as radical as that submission. And the reason it isn't anywhere near that is because we accept the application of the control mechanisms, and as I'll address you on in due course, we say those operate as a very significant brake on the development of the law, and very, very substantially limit the number of potential claims. And as you've heard, and I won't repeat it, that clinical negligence cases, classically the archetypal case involves failing to make the right diagnosis, which may be coupled with commission, making the wrong diagnosis, but it's essentially not treating the disease or illness or injury that needs to be treated. And it must follow from the defendant's position, if they're correct, there's virtually no claim in clinical negligence that will be successful by way of secondary victim claims. And it may be that they will acknowledge that and seek to persuade you, but it's important, in my respectful submission, that reality is acknowledged. And as Mr. Weir very powerfully addressed you on, we have Court of Appeal authority since Walters that has been in place for about 20 years that would suggest very strongly the opposite. And Walters would have to be overruled if the defendant's position is correct. We also say that the defendant's position, so the requirement for an external event, would produce incoherent, illogical and unjust distinctions, inappropriate distinctions. I probably used too many adjectives there. And perhaps if I can put this factual example to illustrate that point, a hypothetical, albeit it bears some close relation to the cases, the facts of the cases that are before you. If one imagines a child at the side of the road who is in cardiac arrest and requiring resuscitation, whose parents are summoned to the scene, and at that point they don't know why the child needs resuscitation. Now, in one version, the reason for the collapse is the doctor's failure to make the right diagnosis at some previous medical consultation. In another, the child has been, say, struck by the car and suffered a chest injury. The injury not being externally horrifying, but the consequences on them being, and the need for resuscitation being extremely horrifying. Why should one set of parents recover but not the other? I respectfully suggest that is not a wild or extreme hypothetical, but one that rather illustrates starkly the sort of results that the defendant's position would produce.
Might it though be said that there is a moral difference between a situation where somebody dies as a result, as it were, of nature taking its course, but in the modern world with medicine it could and should have been prevented, and the situation where somebody dies through human action of a wrongful type that has caused accident and injury?
I mean, there may be arguments that a doctor, particularly given the test for breach of duty for doctors, it's a very high hurdle for claimants. The doctor who's bolum negligent in caring for a 6 or 7-year-old girl is more culpable than the motorist who goes at 35 miles an hour rather than 30, or always distracted and misses the light turning to amber. So I wouldn't accept that someone who dies by natural causes, when that wouldn't have happened but for the negligence of the clinician whose responsibility it was to provide care, should in some way be treated as less morally troubling than the negligent driver. As I say, in many ways one could look at it the other way around. And certainly I would suggest that given the range of possible situations that might give rise to an accident or might give rise to the silent accrual of a cause of action and then a horrifying event, that wouldn't be a good test to identify the deserving from the undeserving claims.
I'm looking at not in terms of how much fault to attribute to the defendant, but in terms of drawing a distinction between those horrifying situations which you have to cope with in life, and the law doesn't provide recovery, and those where if you suffer psychiatrically as a result, the law does provide recovery.
Well, there is still a requirement, of course, for sudden and horrifying events that violently agitate the mind. And as we know from Renane, if the events happen in hospital, it's very difficult for claimants to be successful. So that point is already reflected in that. And no one could, I would respectfully say that it couldn't be said that Mrs. Polmear ought to have expected this in the ordinary course. That they ought to have expected that there'd have been competent medical attention provided to their daughter and that they would never have had to witness this event. So in terms of how that might produce different results, they wouldn't delineate those which were just from those which are unjust is ultimately my suggestion.
I mean, they're all examples of negligence.
Yes.
Whether it's accidents or medical negligence. The key fact is these are not natural deaths.
Yes.
I mean, we might look at the tort system and worry as to why negligence should make all the difference, as against the person who's born, or in some other capacity suffers for exactly the same scenario. But the fact is, our system is based on proving negligence.
Yes, and of course accidents can arise from omissions as well. If one takes, if I may, the Hillsborough situation, it may be failing to close a gate as well as closing a gate. So yes, so for those reasons, our position is that where we say that the law should draw the boundary will produce coherent results and ones which are just. And what our position doesn't do is, as the defendants suggest, open up limitless numbers of claims. The written case makes ominous predictions, perhaps, as to the number of claims that may follow. Page 263, paragraph 41. It said, being part of a group which witnesses only the perceived or anticipated injury to the primary victim is to be part of a limitless and unidentifiable group at the point of reach. And then at page 268, paragraph 63E, it said this: an extension to the exception at this stage will inevitably lead to calls for another extension sooner rather than later. This is precisely the road to virtually limitless liability, against which Lord Oliver and others have cautioned, ruling out further judge-led extensions. And we say that's a complete mischaracterisation of our position and is setting up a straw man. And I respectfully disagree with Mr. Weir.
So what are your key points as to why it doesn't have that result?
The key points are the existing control mechanisms and the way that they will operate in practice.
You say it's a very narrow class anyway.
Yes. It's a point that can be put in a sentence, but I'll put it in a few sentences. The test of close tie, love and affection immediately reduces the class of claimants because...
Yes, but assuming that most people have at least someone who loves them...
Yes.
Are you then creating a situation where every time there is a death from a misdiagnosis, there will be somebody who suffers PTSD and then has a claim? I think that's what's being said against you.
Well, if that was the only test, if the test was simply, have you suffered a psychiatric injury because of your close tie of love and affection to someone who's passed away, yes, that would open up the number of claims dramatically, and we don't need to and we don't contend for that. Because as well as having the close tie of love and affection, you also have to be physically present and proximate in space and time to an event which has to be sudden and horrifying, which
It's got to be a sudden horrifying death.
Yes.
You witness.
Yes.
But there's something inherently subjective about the concept of it being horrifying, because the closer your relationship with the primary victim, the more likely it is to be horrifying to you, even though the nursing staff in the hospital may see it happen almost daily.
Yes, I would accept that nursing staff are, one would hope, are much less likely to be affected in the same way, but that doesn't mean it still has to be sudden and horrifying. It still has to, as a matter of fact, violently agitate the senses of the loved one when they're physically present, not just by hearing about it.
If it's limited to an accident, like a car crash,
yes,
then it really is happenstance whether the loving one is there or not. But once you extend it to them being with the person when they suffer the injury, then your parents or your spouse are more likely to be there because they're more likely to know that you're ill and be taking care of you.
I certainly accept that if the cases are limited to accident cases, then there will be fewer potential claims. Really the point I'm making is, by drawing the limits of the law where we say it is not opening up limitless liability or anything approaching it.
It is opening up liability, but you say in a limited and logical way.
Yes, and the law isn't here simply to restrict claims. And if there's good grounds for the claims, then recovery should be allowed, and wherever possible, the distinctions between the successful and the unsuccessful should be coherent and justifiable. Of course, there still has to be post-traumatic stress disorder. It still has to be reasonably foreseeable. It still has to be a horrifying death that results from negligence, and as I say, in clinical negligence, that would mean satisfying the Bolam test to show that the care fell below the standard of a reasonably competent doctor wouldn't be considered as reasonable by a body of doctors. So these are very, very significant hurdles, and on no analysis, we say, does acceding to our position or open up significant numbers of claims, whether that's put as open-ended approach by Mr. Weir or the more florid way that Mr. Maskery puts it in his written case. And there are, within the cases to which you've already been referred, various observations about the floodgates arguments, which have been deployed for decades, as far as I can tell. And Lord Russell in McLaughlin said this at page 606, E to F. And it seems to be the arguments for and against floodgates.
Sorry, could you just give me that?
606, E to F.
Thank you.
He said, in the last analysis, any policy consideration seems to be rooted in a fear of floodgates opening. The tacit question, what next? I'm not impressed by that fear, certainly not sufficiently to deprive this plaintiff of just compensation for the reasonably foreseeable damage done to her. I do not consider that such deprivation is justified by trying to answer in advance the question posed, what next, by a consideration of relationships of plaintiff to the sufferers or deceased or other circumstances. To attempt in advance solutions or even guidelines in hypothetical cases may well, it seems to me, in this field, do more harm than good. And Mr. Justice Kennedy in Julia and White, a case from over 100 years ago, but comments still apply and were adopted. This is page 980, the bottom half of that page. And this is a passage that was cited with approval in McLaughlin by Lord Edmund Davis, 602H. He said, I should be sorry to adopt a rule which would bar all such claims on grounds of policy alone, and in order to prevent the possible success of unrighteous or groundless actions. Such a course involves the denial of redress in meritorious cases, and it necessarily implies a certain amount of distrust, which I do not share, in the capacity of legal tribunals to get at the truth in this class of claim.
But that's an argument for every case going to trial. What the cases are dealing with here are a recognition that some of the control mechanisms that you mention are not effective if they're only established after trial. because what the courts seem to want to do is identify a category of cases which can be struck out on legal grounds.
Yes.
But that's...
It's perhaps a caution against, and we may hear some later today or tomorrow, extreme hypothetical examples guiding the court unduly when the court has these, I'd suggest, fairly representative examples of these sorts of cases, these sorts of delays. Our position obviously is inherently that the law isn't too lax at present. The secondary victim claims are not some new liberal innovation being recognised a century ago in Hambrook and Stokes. The courts now, and have for some time, readily recognise that psychiatric injuries can be just as debilitating, if not more so, than physical injuries, just as intrusive. So these are long-established claims. And of course, the Law Commission report, to which you've already been taken, didn't, on its detailed review of the law, conclude that the law was too generous or too relaxed or exposing defendants to too much liability. Quite the reverse. The Law Commission's recommendations are much more radical in terms of relaxing the law than anything that you'll hear on the appellant side of this case. And that just puts perhaps a bit of context upon the position that we take. As Mr. Tyack trailed, I was to address you on thus far.
Have you looked at other jurisdictions and drawn comparisons?
Well, yeah, but yes, Mr. Tyack did say I was going to address you on the jurisdictions. It's something that we've looked at, and we've addressed it in our written case. I have to say, I don't place any great weight on other jurisdictions in terms of supporting our submissions. You'll see in our written case the way that things have been dealt with in Australia and in Canada and in Australia. There's been legislation. I don't suggest that this court needs to look outside the jurisdiction for answers. The answers are contained within the cases within England and Wales.
I did look, just so you're aware of it, at the US restatement and some cases referred to in it. And they seem to have a rule which is very similar, you might say, to ours, which is that in order to recover, you have to be a close relative who witnesses the event.
Yes.
Which they seem to define as the injury-producing event.
I don't think any of the parties have made reference to that.
No, which is why I want to put it on the table in case you want to look at it and
we will look at it.
You do want to address it, because I have looked at it and don't want to be taking account of something that you haven't, you're not aware that might influence me.
I'm very grateful for that indication, and we will look at it. And
I also looked, just for completeness there, because there's a Californian case called Dillon and Legg, which refers to some of the English authorities to see what had happened to that.
Yes.
And there's a Californian case about 25 years later called Thing, I think, and La Chusa, something like that, where they decided that it had created too much uncertainty in Dillon and Legg, and they replaced it with something pretty similar to Walcott. So that's something else I mentioned. Those are the two things.
My lords, I'm very grateful for that. Thus far and no further obviously arises on Lord Staines's judgment in the White Frost case. It was part of the policy justification used by Lord Dyson in Novo, but it's also a principle that the defendants have prayed in aid in their written case. And you've been taken to the, if you like, the conclusion thus far and no further. But if I may just briefly touch on the reasons that were articulated by Lord Stayne, and if I may take you to (708) E to F. And here, and I'll leave your lordship, your ladyship, just to read that paragraph. The point I wanted to highlight is towards the end, so 3 or 4 lines up from the bottom of that paragraph, where Lord Steyne said, if, as I believe, there are such policy considerations, it's necessary to explain what the policy considerations are so that the validity of my assumptions can be critically examined by others. And essentially it's that invitation that I respectfully take up. And 4 distinct policy reasons were advanced by Lord Steyne in support of his conclusion thus far and no further. The first is at 708G, where he expressed concern about the complexity of drawing the line between acute grief and psychiatric harm, requiring each side calling psychiatric experts and a costly and time-consuming exercise. My observations are in relation to that are that this is precisely the business of personal injury and clinical negligence litigation. It is expert-heavy. If it's proportionate, the court gives permission for experts on both sides who provide an opinion. They have a duty to the court. If they disagree, there's a joint statement, and invariably a case will settle because not many significant personal injury cases go to trial on quantum.
That's why it's difficult for us to conclude, as we've been invited to conclude, that the fact that there are not a lot of cases following Walters is an indication that it's not actually led to a large number of claims, because those claims may be made and settled because of Walters.
One can assume that they're settled based on the party's interpretation of the law as it stands under Walters. One hopes and perhaps can assume that there's competent representation on both sides, advice as to what the law is, and the parties are finding where the boundaries lie. But the point I would make is that this is, unless you're being asked to abolish secondary victim claims or to abolish the need for a recognised psychiatric injury or for the need for shock, this policy consideration doesn't weigh in the scales on this appeal. The second point, policy argument that is made, which is at 708H, is the effect on potential claimants of the expansion of the availability of compensation. And he excludes fraudulent claims. So in this context, we're assuming that these are genuine claimants that are bringing claims. And respectfully, it's difficult to see how this can be a good reason for denying compensation. Perhaps a sense that the availability of it will have an adverse effect on the claimants. But of course, we have a principle of 100% compensation here, compensatory damages. How can somebody who's unable to work because of their psychiatric injuries, how can it be said that it's in their interest not to offer them compensation? There's no evidence base for suggesting that litigation is sometimes an unconscious disincentive to rehabilitation. The modern approach,
it's just as much for physical injuries as psychiatric.
Yes, absolutely. And the modern approach to, certainly in cases where liability is accepted and there are serious injuries, is for the parties to engage in rehabilitation, to collaborate, to have interim payments to fund rehabilitation, the purpose of which is to give access to therapies and treatment so that people get better and their losses are minimised. The third one, 709C, which is singled out as important, essentially is the floodgates point, increasing greatly the class of persons who would recover damages. And I've already addressed you on that and don't need to repeat it. And the fourth argument at 709E is that the relaxation of the rules may result in a burden of liability on defendants which may be disproportionate to the tortious conduct, such as momentary lapses in concentration. And respectfully, I would say that there's no basis in law for any sense of proportionality between the extent of breach and the consequences of breach. the amount of damages will depend upon the extent of injury and the impact upon the claimant. It's never depended upon whether somebody was driving recklessly or carelessly, for example. And of course, one can conceive of many examples.
It's really inherent in his third factor, isn't it?
Yes.
So it's one thing for a doctor to be liable to his patient if he's negligent in his diagnosis, quite another to be liable to his patient and the patient's family.
Well, except, and as I've addressed you on, our position is a very limited, if it's an extension at all, yes.
I'm just looking at what Lord Stain is saying.
Yes.
And for my part, I can see that there's no general proportionality principle between culpability and quantum, as we know. But,
yes.
But if you see it in the light of his third point, I think it probably makes sense.
Yes. So really drawing this together, my submission
is there a point that this court, it's a bit of an elephant in the room, that this court should take account of, which is that defendants in these clinical negligence cases are likely to be NHS trusts, and that this extra money for these claimants is likely to have to come out of NHS budgets? Or is that a factor that's relevant?
We would say that wouldn't be a reasonable factor to take into account.
Why not?
Because we already have a system that provides for redress and recompense for those who are the victims of clinical negligence.
But the question is, how far does it extend to third parties, really?
Yeah.
Third parties in the sense that they're not the primary victims.
Yes.
And normally, losses suffered by other people than the victim are not recoverable. So this is an inroad into that.
Well, if it's not within existing principles, I mean, all secondary victim claims are, by their nature, secondary, even if they aren't derivative claims in the technical sense.
They might be seen as greater extensions from a professional negligence liability, which is generally speaking closely client-focused, than extensions from an ordinary negligence liability where you must drive in such a way as not to injure anybody with whom you come into contact on the road.
Yes, but of course, in the professional negligence context, one isn't, not that I can think of quickly, that the professional advisors are unlikely to cause a horrifying physical event to manifest itself.
No, I'm just speaking purely general terms, that clinical negligence is an aspect of, I suppose, professional negligence.
Yes.
Where I don't know about a governing principle, but a constant feature is the focus on the relationship between the professional and his client, or the doctor and the patient, and that being the person to whom the duty is owed.
Yes.
So that the intervention of duties to third parties is a bigger thing in that context than it might be in an ordinary RTA situation.
I don't accept necessarily that it is a bigger thing in this context, because all of these cases involve something beyond the primary victim, whether or not the primary victim was just imperilled. So in the sense, of course, in the sense there is an extension in terms of the number of claimants. And as long as the court is satisfied that the way that the law is articulated by Purchase and Polmear doesn't leave open-ended liability for limitless claims or draw the boundary too far, then the court can be reassured about the consequences of permitting recovery in these cases. And of course, there will be medical practitioners who are providing private medical provision as well as NHS providers.
It will be well insured.
One would hope so. You've already had able submissions as to why this matter doesn't need to be left to Parliament. I'm not going to repeat them. I endorse them. Just moving on and coming towards a conclusion of my submissions, looking at the proposed test by Mr. Weir, the Paul test, and it would seem that there's been a modification from the Court of Appeal where, as I understood the position to be, that if there was any manifest damage prior to the horrifying event, that would debar a later claim. And it seems that having met with some resistance judicially, that's been modified to a more flexible approach. Not one that's defined clearly, I have to say. And our primary position, as Mr. Tykes explained, is that the control mechanisms, as drawn, answer the question of proximity. We have concerns as to how this would operate in practice. We don't see any precedent for it in previously decided cases. We aren't convinced that it will produce coherent results and won't lead to inappropriate distinctions. And perhaps that's best illustrated by, if I may, using the facts of Paul itself. What if Mr. Paul had a significant angina attack the night before that wasn't witnessed?
Or some time before.
Or some time before.
So you had then have inquiries about how major does it have to be before it counts as the incident?
Yes.
How many of them can you allow, and that sort of thing?
Yes. What is manifest? If it's not the accrual of the cause of action, when does it then tip into being manifest? Why does it have to be the first manifestation? If one takes that perhaps the paradigm that the primary victim has died, how do you prove it's the first manifestation at trial if the burden of proof is on you to establish the ingredients of the duty of care? How do you establish the negative that there hadn't been an earlier manifestation? So our position is it's unnecessary because of all of the other controls that remain, but it also produces unworkable results. And
what happens if the first manifestation is in a context where it's not foreseeable there'll be any loved ones present?
Well,
like work, as in the,
yes.
I think in the Novo case.
Yes. My tentative suggestion would be that reasonable foreseeability would be considered understanding what in fact had happened. And I'm not, thinking on my feet, convinced that it would need to be foreseeable that they would be present. But rather if
or
present.
in the immediate aftermath.
Yes.
I mean, otherwise they wouldn't be
Yes.
able to be shocked in the relevant sense.
My Lord, yes, the injury would need to be reasonably foreseeable, but my initial response is that one would assume that they're present, and it's proximity which then regulates whether the law decides that they're outside the reasonable contemplation of the defendant, and perhaps that's where the unexpected presence arises. Obviously, not an issue that arises in fact for these claims, but I hear the observation.
While it's been touched on, what do you actually say about the Novo decision? Are you simply adopting what Mr. Tyzak said about that? I mean,
yes.
He was ultimately saying, as I understood it, that we would probably have to overrule it. I mean, he did try to perhaps steer clear of that to some degree, but I felt that his main thrust was, yes, we'd have to overrule Novo. Is that your position?
Yes. For the reasons he's articulated, and it may be that where the decision went awry was when the test of proximity morphed from being the control mechanisms into something distinct. Well, it's not something distinct. The control mechanisms are the test of proximity. But yes, I accept that on our position, Novo would have to be overruled, and on the defendant's position, Walters would have to be overruled, I would suggest. The defendants, again, and this may be something that's best left for reply to hear how it's articulated by Mr. Mascari, also hint at perhaps a general, more flexible consideration of proximity. And rather than try and second guess how it's going to be put, I'll save that to reply. You've already had my submissions on the facts that really whatever version of proximity you applied, if you applied something more flexible, Mr. and Mrs. Polmear must have been in the reasonable contemplation as a matter of law of the defendant trust. And there's nothing in, for strikeout purposes particularly, there's nothing in the history that actually could be described as a first manifestation for Esme. Certainly nothing that was horrifying, nor a previous accident. So on none of those tests should this case be struck out. Those are all my submissions. I've finished early.
Well, thank you very much.
Thank you.
Very helpful.
Unless I can assist any further.
No. Right. Well, now we're up to Mr. Mascari. Slightly early, but that isn't an invitation to go longer than you had planned.
my lords, my lady, I intend, subject to your blessing, to finish this afternoon by 4. This afternoon. Tomorrow, it may be that there will be some additional submissions, but they won't take terribly long, I hope.
You'd like to carry your bat.
Absolutely. To be told where I'd gone wrong. I know that my lords, my lady, will want to get into the question of, are the control mechanisms that we are suggesting sensible or not? At some point we have to get there. But my submissions are going to start on the basis that Alcock is the controlling decision. Therefore, we have to decide what Alcock was considering, what Alcock decided, why it decided what it did, and whether
I'm sorry,
it was
you're going a little too fast for me. I'm sorry.
I'm so sorry.
Could you give that again, if that's possible?
We have to ask ourselves, what was the question or questions that Alcock was deciding? What did they decide? Why did they decide it? Were they right or wrong to have made those decisions? And that will require us to spend a little time with Alcock. And it will require us to consider 2 issues. What is meant by legal proximity and what underpins legal proximity? I won't in any detail, if at all, refer to the decisions prior to Alcock, save for McLaughlin, because Alcock is the controlling decision. And the previous decisions mark the development of the position that the House of Lords faced in Alcock. The decisions that come after Alcock are clearly of interest, but in essence, there were 2 Court of Appeal decisions that sat very uncomfortably with each other. Walters on the one hand, Novo on the other. And what the Court of Appeal in each case was considering and what they took from Alcock may assist my lords, my lady, in reaching the determinations that you do. But it isn't of great significance whether this court chooses to accept or reject a Court of Appeal decision. It's whether the Court of Appeal decision was right or wrong, and whether ultimately Alcock was right or wrong. I said before I came to Alcock I would mention McLaughlin. It's important in my submission to recognise that in McLaughlin there was a root and branch attack on the need for legal proximity. The thrust of the argument was that reasonable foreseeability will do. And because reasonable foreseeability will do, and because shock or psychiatric injury consequent upon coming onto the aftermath of an incident was reasonably foreseeable, that's all that needed to be established. And the attack failed 3-2. And my Lord, Lord Burrows, took the court to the facts of McLaughlin and emphasised that actually what happened there was that the claimant came upon the victims of an incident and sustained shock thereby. But the link between the aftermath is to the event, which is the accident. Because if one reads what they came upon the victims covered in oil and dirt, blood upon their face. It all comes back to, it's the aftermath of something that was inflicted upon them. It's the aftermath of an accident. It's the aftermath of an incident. It's the aftermath of an external event to the primary victim.
Do you say it would make all the difference if the oil had been cleaned off the victims?
Well, sadly, that is the claimant's position, because actually what they are saying to my lords, my lady, is that if one comes across somebody who has died a few minutes previously, a few hours previously, from natural causes, that can be the event that they rely upon. Because they say the event is the fact of the death or the fact of the injury. And if an aftermath principle exists, that's the aftermath. It goes wrong because actually, as my Lord Burrows mentioned, you can't have an aftermath of an imperilment and the aftermath of a death or injury consequent upon natural causes is exactly the same as if somebody had died of natural causes in any situation. It doesn't work. But we'll come back to that if we may.
I don't think you quite answered my question.
Well, that's...
I'm sorry to
terrible of me.
I think you were making the point that, as I saw it, you're absolutely right, of course. What was being seen was injuries, and you're making the point, well, it wasn't just injuries, there were elements of the accident itself.
Yes.
And one can talk about, in that sense, the oil, I mean, maybe torn shirts or whatever it was. And my question to you was, would it make any difference if there was no oil or torn shirt, do you think? Is that your submission, that it makes a critical difference?
My Lord, it makes a difference because it makes a difference as to whether it can be regarded as horrifying. Horrifying has to be determined on an objective basis. And I come to my Lady Rose's point that she's made a number of times during the submissions, which is that if you are going to say that the event can be simple death or injury, witnessing the death or injury, then the courts are going to be focusing on whether that was horrifying. And to utilise what Professor Stapleton used to say about the dignity of the law, it is frankly a horrible investigation to have to undertake. Is what you saw going to be regarded as objectively horrifying? Not only is it a horrible thing to have to do at a trial, it's a very difficult thing to do at a trial, because what is horrifying objectively to one person isn't necessarily horrifying objectively to another. And it means that if we are right when we say it has to be an accident, an external event, etc., the number of occasions when you're going to have to be investigating the horror of the death or injury or imperilment will be limited. Won't be removed, but will be limited.
So is the answer to my question that it depends on whether the oil and torn shirts meant that the injuries, or indeed the death, cross the line to being horrifying or not? That's your submission.
Two answers. That is one. The other is, for there to be an aftermath, there must be a link to something. It has to be a link to the event. The only event that there can be is the accident, and that's what happened there.
Yeah. Well, of course.
and therefore, to take my Lord's point, if the victims had been cleaned up, as you put it, if they were lying in their hospital bed, if, even worse, they had been taken to the mortuary and they were at the mortuary cleaned up, etc., etc. However horrifying that might be to the potential secondary victim, the close relative, that would not be regarded as the aftermath, because there's no actual link remaining with the circumstances of the accident.
But that's a separate point. Let's just assume for the minute that it could be shown that removing the oil and cleaning up, let's just assume that that would not stop the satisfying of the objective horror of what was being seen. And I think from the way you're nodding, you're accepting that is a possibility.
Yes, it is.
Yeah. We've then got the separate point about what is the time that one is actually talking about for the immediate aftermath.
Exactly, which is why I make the 2 points.
Yes.
You've got to look at the horror, but in addition to that, there's got to be some sort of link between the circumstances that the claimant comes upon and the original event, whatever that might be.
Your link point is a separate requirement, even if it's still horrifying after the cleanup.
Yes.
Yeah.
And it is important, they treated it, I think, as important, or Lord Wilberforce did, that what was perceived was not just injuries, but the experience was of injuries caused by an accident.
There is a link between the event, which was an accident, which enables one to say that it falls part of the immediate aftermath.
So you're saying if something's an aftermath, it's got to be after something, and that's the accident. But if we extend this so that it's the event of injury, then you'd say, well, what is the aftermath of the event of injury? And then you start getting quite attenuated.
Absolutely. Demonstrated by Lord Burroughs' point yesterday that realistically you can't have an aftermath of an imperilment.
Just on what Lord Wilberforce was saying in McLaughlin, if one looks at page 596 in the bundle, one sees from E onwards that he builds out from clear accident cases to people coming directly, the family member coming directly to the roadside, not having been present. And then the whole examination is about whether one can extend from that to the situation where you go more than 100 yards. So in McLaughlin, there was a car journey involved, but when you come upon your relatives, I'm looking at it at F, they were in the same condition as they would have been on the roadside, covered with oil and mud and distraught with pain. And I think he goes on to say at G that one ought to draw the line such that the claimant in McLaughlin falls into the same category. But he says to allow her claim may be, and I think it is, upon the margin of what the process of logical progression would allow. So he's pushed it so far, but even he's saying that's as far as I think it ought to go.
Absolutely. Absolutely.
Of course, it might be said against you, well, of course, this is an event case. It's an accident case, an event that is an accident.
My Lord, absolutely. I am not suggesting that either in Alcock or in McLaughlin anybody said in terms, we'd just like to make it clear that these are accident cases and we're only restricting ourselves to accident cases, or alternatively, although this is an accident case, we are making principles of more general application. I'm not suggesting that. What I will be coming on to suggest, though, my Lord, is that in Alcock, that is the necessary inference to be drawn. In other words, that when one looks at 3 issues in Alcock, we can conclude that they had not simply forgotten that there could be cases that were not categorised as accidents that might lead to psychiatric injury for a secondary victim. Moreover, they had actively considered that, and when they were referring to accidents, incidents, the infliction of injury, they were taking that into account. And the 3 factors are going to be: 1, the control mechanism itself; 2, the language that they used; and 3, the categorization of cases. What do I mean by categorization of cases? What I mean is that they took cognizance of the concession Mr. Weir made, that there had been no previous case that had not been an accident. They were looking at what cases had succeeded, what type of cases had succeeded. They were saying it is too late to say that they should be swept aside. We have to accept that those are exceptions, I would put it, to the rule, but all we're going to do is allow the exceptions that have been found to date, and we're not going to extend them any further, save in 1 or 2 cases where one can see that there is a justification for a degree of flexibility. And those 2 cases are what's meant by ties of love and affection, and what's meant by aftermath.
When you say the rule, which rule are you here talking about? Are you talking about no liability for psychiatric illness?
Yes. The starting point is that looking at legal proximity and looking at it in Donoghue and Stevenson terms, there is no liability to a secondary victim. And that is manifest by 2 submissions. 1, the reference by Lord Atkin in Donoghue and Stevenson to direct. It has to be within a defendant's reasonable contemplation at the point of the breach that his or her actions will lead to an adverse consequence directly. And that means to the primary victim.
Do you have a bundle reference just for our notes for that? Or are you going to come back to it?
I'm going to come,
All right.
but I think it's 924, but it's Donoghue and Stevenson's, and I'm going to refer to it when one comes to Mr. Justice Hidden's decision in Alcock, because that's what he refers to specifically. So 1, that point, the directness, but 2, the fact that there had been, what Lord Oliver was attempting to do was to say, well, what cases have been decided as an exception to the general rule that there's no recovery. Here are the categories of exception. We have to live with those, brackets, though we know that it's given rise to difficulties, and save in the two respects that I've already mentioned, we will go no further.
Can I just ask you this? Is the rule that you are saying that this is an exception to confined to secondary victims, or is it the rule that there was no recovery for psychiatric illness by anyone?
No, the rule is that there can be recovery for psychiatric injury by a primary victim. The rule was that that does not extend to a secondary victim.
Was that prior to Alcock? When could you get psychiatric illness by in tort of negligence? Sorry?
Well, McLaughlin is the secondary victim. Yeah. In primary victim care.
Prior to McLaughlin, I beg his pardon.
Yes, well, that's why I start at McLaughlin.
No. What I'm asking is your proposition confined to secondary victims who recover, who suffer from psychiatric illness, or is there a wider rule that you cannot recover psychiatric illness in the law?
First. I am submitting that the general rule is that a claimant who is a secondary victim cannot claim for any adverse consequence upon a defendant's actions or omissions, but that there developed prior to McLaughlin exceptions to that rule, and those exceptions to the rule were confined to circumstances where there had been an accident or incident, and that accident or incident had given rise to psychiatric injury to a bystander.
If Mrs. Boorhill had not been behind the tram, she would have recovered.
Yes. Yeah. And we can see the development. It didn't come at once. We know it didn't come at once. It was a stage-by-stage development until we reached the stage at McLaughlin and Alcock, at which there had been these, Mr. Weir used the expression, islands of recovery. I would prefer to say exceptions to the general rule that so-called secondary victims don't recover. And just to make the point, secondary victims don't recover. If my daughter has suffered cerebral palsy as a result of a breach of duty on the part of the defendant, and I suffer physical injury because I have to pick her up and take her up and down the stairs, no recovery. If I suffer psychiatric injury simply as a consequence of understanding that my daughter has cerebral palsy and living with that on a day-to-day basis, no recovery. Why is there no recovery? Because the general rule is that secondary victims don't recover. And we can see it in the economic climate as well. I am injured, I am a great salesman, my employer doesn't have the benefit of my services, suffers economic loss, no recovery. Doesn't matter how foreseeable it is.
Is that right? Is that right for your first example? Your example, as I understand it, was it a claim against the doctor? Or
a claim against anybody. A claim against anybody. If I run you down,
yes,
and you suffer injury,
yeah,
and your wife, as a consequence, suffers injury having to look after you.
Well, it would turn on whether it was reasonably foreseeable.
No, it's just not recoverable. It is reasonably foreseeable. Of course it's reasonably foreseeable.
I think Lord Roger discusses this in the case we were provided with JD in East Berkshire, for example.
There is no circumstance, my Lord Burrows, there's no circumstance in which If I injure you and somebody else sustains physical injury consequent upon looking after you, that there can be recovery.
And we need to be very clear what we mean by secondary victim in this context. It means someone whose loss, be it physical or psychological, is the consequence of what has happened to the primary victim.
Yes.
Yes.
Well, I'd like to see authority for that proposition. The first proposition. I entirely accept what you say on the second proposition.
Can you remind me what my first proposition was?
You're talking about somebody who is caused physical injury as a consequence of a physical injury to someone else, but there's been a breach of a duty of care and it's foreseeable that the so-called secondary victim will suffer physical injury. And you say you can't recover in that circumstance.
You can't. And you ask...
Can I have the authority for it?
And there is no authority because it's a negative proposition.
Never been a recovery.
There aren't cases where there is recovery in those circumstances.
Well, there may be indirect recovery in that the injured person may recover the cost of care, which is a different thing.
Now, my lady, that is another of the islands of recovery, the exceptions, and that's caused its own difficulties. Because the way in which it was dealt with was to say, well, of course, the mother looking after the injured child has no claim. So how are we going to provide for the obvious public policy principle that she should receive something for looking after her daughter? Answer by saying that it is the primary victim's claim. Not by saying, oh, we're going to actually make an exception here, but by saying it is in the interests of the primary victim to be able to encourage someone else to look after them. And one of the ways in which they can do so is by defraying out-of-pocket expenses or something of that nature. Therefore, it is the claim by the primary victim. The money may be then transferred to the person looking after them.
I accept that entirely when you're talking about, as you are there, pure economic loss or psychiatric injury. I'm only putting to you that you are making, I think, a wider proposition.
Yes, I am.
That secondary victims, even those who suffer traditional personal injury, cannot recover, even if within Donohue's and Stevenson rules, i.e. they're reasonably foreseeable. And all I'm saying to you is that strikes me as a problematic proposition. You can't give me any authority for it. Well, but, maybe I can't give you any authority to the contrary.
My Lord, the reason, of course, is nothing to do with foreseeability. It is eminently foreseeable that if I injure you, others may sustain not simply economic, but psychiatric or physical injury consequent upon that. That's eminently foreseeable.
Right.
One only has to put the proposition, I suggest, that if a child with cerebral palsy is injured, as a result of which she cannot be taken up and down the stairs and the parents are going to have to do it, it is eminently foreseeable, looked at with the benefit of hindsight, because that's what foreseeability does. Looked at with the benefit of hindsight, it's eminently foreseeable that they may suffer injury. But they don't recover. Why don't they recover? Because there's no legal proximity. There's no relationship between the defendant and the claimant. And that's why I say we've got these, my Lord Legate's words, inroads, Mr. Weir's roads, islands, my word, exceptions, that have developed solely in relation to psychiatric damage suffered by secondary victims. And my Lady Rose's point about the gratuitous care that is provided is dealt with by the mechanism that I put forward.
That looks like a convenient moment to pause.